What's up, everybody? And welcome in. I hope everybody is doing awesome. We're going to talk about something today that a lot of you asked about, but I think we're going to go through the motion. We're going to talk about whether or not Johns Hopkins can remove this juror, the reasons they're going to discuss why they think this juror has to be removed. I'm sure Maya and her team will object. And we're talking about the Take Care of Maya trial, Maya Kowalski and family versus Johns Hopkins All Children's Hospital. Trial's been going on. It's coming to an end. And now the defense is moving to remove one of the jurors. And it's basically all based on the jury questions, which leads us to kind of this overarching theme and question that we have in these cases. Some people are always shocked when they see jurors can ask questions. I always talk about how I love it because you start to see where the jurors are, where their heads are, where they're leaning, what questions they have, so you can answer them and make sure that they are not left wondering something that you have the answer to on your side in a case. And that's the point of the jury, to ask questions. They're going to think certain things, believe certain ways, want to know certain things, want certain evidence, whatever it may be. And you find that out a lot of times with jury questions. And when you don't have jury questions, it doesn't mean the jurors aren't thinking that way. It just means you don't know it. It's kind of like when we talk about juror interviews after trials in cases. It's good to hear what the jurors thought and what they considered. Because if we don't hear from them, we just don't know. It doesn't mean they don't think it. It doesn't mean they didn't do that. But it opens the door to all kinds of issues. We have these laws written and these rules and statutes in a way that are kind of like a utopia, like the golf, they say it's the honor system. It's kind of what the jury system is like. We tell the jurors, here are the rules, and we expect them to follow them. We trust them to follow them. We believe that they follow them. Even though society kind of generally tells us people don't always do what's right. Sometimes people lie. Sometimes they say they're going to do something and they don't. We don't ever want to believe that's true. But in this system that we have in American jurisprudence, we generally believe and give jurors the benefit of the doubt. And in order to prove that there's some kind of misconduct or to get some change to happen because of what a juror does, you have to actually prove that misconduct. It can't just be we think or we believe or we surmise. You have to actually prove it. And we've seen it based on some of those juror interviews in other cases. We've seen jurors even called into court and questioned after getting an attorney and have to be granted immunity, like in the Ghislaine Maxwell case. So we've seen issues that have been created just from knowledge and pulling back the curtain of what happened back there and what you all discussed. You can't be forced to talk about it, but if you do talk about it, it could potentially make a difference. And we've talked about whether that's good or bad in the situation with appellate issues and after convictions or verdicts. And we don't want to have to do it all over again. But if something bad went back there, I want to know the truth. And I always err on the side of the truth and knowing that truth. And if the truth causes an overturned case on appeal or a juror to get disqualified, then so be it. I think I land on the side of letting these jurors speak. Let them be interviewed. Let them ask questions. Let's see where they stand. Let's make sure they're fair and impartial, because we put this whole system in place of jury selection to pick fair and impartial jurors. So why are we saying now we don't want to hear them speak? Don't give interviews. Don't ask questions, because we don't want to know if we actually picked a biased juror. We don't even want to know. We just want to assume we did it right. That's not where I stand as a trial lawyer, because I know that can be incredibly problematic for trials. And sometimes that can come back to bite me, right? If a juror gets disqualified and they were actually biased toward my client or in favor of my client. But at the end of the day, we want a fair and unbiased jury. We wouldn't want it to happen to us. Treat others how you want to be treated. All of those principles still ring true. So let's take a look at the arguments Johns Hopkins All Children's Hospital makes in this case. We'll go through, we'll label them in the comments. Feel free to run along with me as legitimate or just nothing burgers. Bringing that term back, and the judge in this case even said it. I think another lawyer in this case said something was a nothing burger. And we're going to go through, and basically it's all the jury questions. That's it. And then we're going to get some law on how you determine whether or not a juror needs to be disqualified based on misconduct or showing impartiality, or showing partiality, I should say. All right, here we go. Defendant, Johns Hopkins All Children's Hospital, Inc.'s motion to disqualify juror. Defendant, Johns Hopkins All Children's Hospital, Inc., by and through undersigned counsel, move this court for an order disqualifying juror number 1 from serving on the jury, which deliberates to decide the above styled case. the defendant submits that juror number one on multiple occasions and through multiple questions and statements communicated to the court in connection with questions has revealed, one, a bias and prejudice in favor of plaintiffs and against defendant. So it's not just that they like the plaintiff, they also hate the defendant. And two, a violation of this court's instruction to the jury not to form or express any opinion about the case until retiring to the jury room to consider the verdict after having heard all of the evidence, the closing arguments of the attorneys, and the charge of the court. See Florida Standard Jury Instruction 1.1. In support thereof, your movement states as follows. So they show bias toward the plaintiff against the defendant, and they've made up their mind already, which the court says not to. So some of the questions I have are, do you think jurors really sit there for weeks and weeks and weeks and make up their mind about nothing? I don't think that's the standard. And we're going to read through some of this. I think the standard is made up their mind about the result of the case. And how do you prove that a juror has made up their mind about the result of the case? It's not make up their mind about whether or not they believe a witness, which we're going to hear some of in here. I think a juror can sit there and be like, oh, okay, yeah, I believe this witness. That doesn't mean they should be disqualified. Think about that. If we knew whether a juror believed or listened to these witnesses a certain way and they're disqualified each time they think a witness is telling the truth, even before they've heard another witness, that's not the standard. Throughout the trial of this cause, oh, by the way, why only try to strike one juror instead of two? Because we heard the defense might try to strike two jurors. I think you don't want to stretch it. You pick your best argument, the worst juror that you feel like you have the best argument to disqualify, try to disqualify them. You don't want to get the waters muddied. If one is really kind of a weak argument, maybe the judge is going to be like, you guys are reaching. I'm not disqualifying either of these. So get rid of the weaker argument. Keep the best is my guess. Throughout the trial of this cause, the jury duly sworn to hear this case, along with the alternates selected, appear to have paid diligent attention, and their attention has been reflected in a substantial number of juror questions. In the process of posing such questions, however, one juror, number one, has repeatedly revealed not only a substantial bias and prejudice in favor of plaintiff and against defendant, but also a violation of the court's instructions as set forth in Florida Standard Jury Instruction 1.1 that he or she should not form or express an opinion about the case until you have retired to the jury room to consider your verdict after having heard all of the evidence, the closing arguments of the attorneys, and the charge of the court. Juror number one statements evidencing the above include but are not limited to the following. Most recently, in questioning nurse Sylvia Ballweg, a witness called by the defendant, the juror prefaced a question by making a statement to the effect that the witness was a breath of fresh air, or words to that effect, since she was the first person from defendant who appeared to have cared about Maya Kowalski. That is a nothing burger. That to me is, you have to connect a lot of dots and surmise a lot of things from that statement. There's no way, in my opinion, that alone would be enough. But we will see if piled on top of some other things, it rises to the level of showing this partiality. B, in a question to defense witness Kelly Thatcher, APRN, juror number one asserted that his ethnic background was the same as the decedent Beata Kowalski, with the result that both the juror and the decedent tended to be pushy. Juror number one stated specifically that he identified with the decedent and questioned whether the witness had overreacted to the decedent, suggesting a belief that she had done so due to the decedent's ethnicity. Some of this is going to be hard if the defense is putting their spin on it, or if this is actually exactly how it went. So I'm just going to give them the benefit of the doubt as we read through this motion that this is actually what was said, because there's certain things that are quoted and other things that are not. I'm not calling them liars, but I'm saying maybe these things they're taking 3 or 4 steps and connecting dots that maybe I'd have argument with or take issue with if I knew all of the details of what was happening at every sidebar. Every time these juror questions are presented, we only hear some of them. But if this juror said that they identify with the decedent Beata Kowalski, they also think that they're pushy, and because of that, they think a witness overreacted, and they feel personally that this witness would overreact to them as well. This to me is not a nothing burger. This is a legitimate issue. Overly identifying with a victim in the case and feeling like you're being treated like the victim as a juror could potentially create an issue where this juror might need to be removed. With a couple of other things that we'll talk about at the end is how they would deal with that. This to me, B, number 2, is probably the most significant issue this juror may have. If I was the defense, this is the one I would focus on. C, juror number 1 asked a question of an early witness stating there appears to be probable cause of improper action by Sally Smith in her assigned role at J Hatch. thus indicating that the juror had formed and was expressing an opinion regarding the case and the evidence in violation of the court's instruction and indicating a predilection against defendant. I vehemently disagree with this. This is a total nothing burger, in my opinion, especially since they left in quotes that there appears to be probable cause. The plaintiff makes all sorts of allegations in the complaint. The plaintiff makes allegations in the opening statement, and they know the allegations at this point. And they're saying it appears that there's probable cause for improper action. It doesn't mean they've made their decision. Frankly, it means their mind is still open about it to me. And that's the argument I would make if I was the plaintiff in this case. I don't think that one's going to work or going to win the day. D, juror number 1 expressed an opinion in the preface to questioning of a witness, indicating an understanding CRPS can come and go, get worse, or reside / disappear, thus reflecting not only an opinion about certain matters in the issue, but an acceptance of plaintiff's evidence before having heard defendants. Again, this could be saying understanding, meaning setting up a hypothetical for the witness. Number 1, saying like, let's say CRPS can come and go. And then they ask a question. Number 1. Number 2, forming an opinion on as to whether or not CRPS can come and go or get worse is not an ultimate issue in this case. It doesn't mean Maya has it. It doesn't mean she doesn't have it. It doesn't mean the hospital did this or didn't do that. It doesn't mean they falsely imprisoned her or didn't. So making the statement doesn't come anywhere near, in my opinion, forming an opinion that is precluded from the jury. Are they supposed to not form the opinion that Dr. Jones is Dr. Jones because Dr. Jones said they're Dr. Jones and they said they went to medical school at Florida State University College of Medicine? Can they not form an opinion that that person is a doctor? We cannot stretch it this far, in my opinion, to say that this is a precluded opinion in the case. And again, some of these questions, in my opinion, is going to be something that we have to discuss in Florida and other states that allow jury questions. How are we going to deal with this? Are the questions going to be a major reason why jurors get disqualified? And they cite a case here that we'll talk about. Questioning various witnesses called by the defense, including Charlotte Laporte, in an adversarial manner, confronting her with questions regarding whether she can beyond doubt affirm that, or whether she was, quote unquote, able to attest to matters she addressed in her testimony, specifically those related to Catherine Beatty, and telephone calls, again indicating an adversarial predilection against said testimony and in favor of plaintiffs. A couple of reasons why I think this is a nothing burger. Number 1, lawyers all the time want to ask, are you sure? Can you say with 100% certainty? And number 2, just because they may not like or think one of your witnesses credible or various witnesses doesn't mean they've made an ultimate decision. And frankly, by asking this question, if your witness can say, yes, they can affirm this or that, then maybe they'll believe it and continue on. F, questioning witnesses, including Miss Tori Nihas, as to whether her team or the hospital possessed certain photographic or video evidence. By posing this question long before testimony has concluded or arguments submitted, the juror has indicated that a burden has been placed upon the defendant above and beyond any contemplated by the court. Again, nothing burger, in my opinion. Just because they ask for photographic or video evidence, which again, lots of lawyers ask for in cross-examination, you have all these videos. Do you have videos of that? You have all these pictures. Do you have pictures of that? We've heard it in the Adelson trial. Asking for photographic or video evidence does not create a burden beyond any contemplated by the court. Unless they say, without video evidence or photographic evidence, I won't believe anything this witness says. That's problematic. And usually that's handled on voir dire, where we talk to the jurors and we say, this isn't CSI. There's not going to be a DNA test for everything. There's not going to be a photograph or undercover recording or video of everything. Is that okay? Or who needs evidence like that or can't make any decisions? A lot of times we talk about that in jury selection. I don't think they're saying that at all here. Just frankly asking if they have more to back up their testimony could maybe say, I don't really believe you right now, but if you had this stuff, it would help. G, in questioning Ms. Laporte, the juror in question began a question with a representation that plaintiffs had provided a dress for Maya Kowalski to defendant for Ms. Beatty, indicating prejudgment of the evidence with respect to that issue and without having heard all of the evidence pursuant to the court's instruction. Again, this one depends a lot on context. The decision or that they have made or the opinion that they have formed is that, I guess, a dress was provided for Maya Kowalski. And if you think, and let me know in the chat, do you think jurors as they're listening, don't start thinking, okay, Maya was provided a dress. Do you really think that they don't make a single decision or form an opinion on any fact before they go back there? They obviously do. They have to. That's why they take votes half the time when they go back there. They've obviously been forming opinions. That doesn't mean that they have formed the ultimate opinion on guilt or innocence in a criminal case or on who's liable and for how much on a civil case. And I think it may be a gray area and judges are going to have to make calls. In the same question set, the juror in question confronted Ms. Laporte with questions regarding whether she knew the dress in question resided in Ms. Beatty's office and or whether whether the witness knew it was not timely given to Maya Kowalski, indicating an acceptance of plaintiff's evidence before having heard all of the same, and indicating an opinion with respect thereto, both of which violate the court's instruction. Nothing burger again for H. For me, to me, if I was the plaintiff's attorney, I would also say, Judge, some of these juror questions sound exactly like the questions each side and each team of lawyers were asking. So maybe they were taking our lead and asking questions the way we ask them. Because a lot of times I would ask questions like that. Did you know where the dress was? Well, there wasn't even a dress. Oh, and we ask, so maybe they're just taking our lead and asking similar questions. Questioning at least one witness with the preface that plaintiff Maya Kowalski was more mature than a usual 10-year-old and had handled her pain differently, thus expressing opinions that reflect acceptance of plaintiff's evidence and testimony and expressing opinions regarding the same, again, in violation of the court's instruction. So this leads me to, are jurors not even allowed to form an opinion if all of the evidence is consistent and basically stipulated to? Did anybody say that Maya was not, maybe not more mature than usual, but handled her pain? I feel like everybody was talking about how she handled her pain. And forming the opinion of that she's more mature than a usual 10-year-old, how does that decide the case? She could still lose even though she's more mature than a 10-year-old. I would say that it's probably a positive view of Maya, but that could be coming from the trial, which kind of is how it works. They weigh the evidence, determine who's credible, who's not credible. They learn about witnesses, and that stuff's all in their head before it doesn't just magically pop into their head when they're in jury selection. And again, this is part of kind of the honor system and how the system is set up. When we're not in the heads of the jury, I don't believe that. When I'm trying a case, I know jurors are determining who's credible, who's not. What do they believe? What do they not believe? What else do I need to give? Videos, photos, whatever, to prove these things to them? We know that happens. So let's not be intellectually dishonest and act like it doesn't. J, questioning a witness, Stephanie Graham, in an adversarial manner. Again, they got to define that. Regarding statistics related to the success of her case ratio and also regarding her interrogation of Jack Kowalski, despite the witness's own testimony, the discussion in question with Mr. Kowalski was an interview, not an interrogation, thus indicating an adversarial attitude and bias against defendant's witness, as well as implicitly expressing an opinion or conclusion regarding the case long before the evidence is ended. Judge, in their question, they didn't use the word we wanted them to use. There was two words they could have picked. So if they would have said interview, does that mean they're biased in favor of the defense? If the defense is calling it an interview and the plaintiff is calling it an interrogation and they use the word interrogation, that cannot be disqualifying. I know there were cases where, like in a DUI case one time, we were fighting a breathalyzer, whether or not it was working or not. We called it a machine. The state called it an instrument for a million different reasons we're not going to get into right now. So if a juror would have asked the question about the instrument, does that mean I can say they're biased toward the state and they need to be disqualified? No way. Questioning witness Richard Elliott in a sarcastic and biased manner, indicating an opinion regarding the subject of his testimony. Now, if too many of this jurors' prefaces to their questions are sarcastic and combative and adversarial, I do think that could create a problem. I do. Not forming an opinion as to whether or not Maya was in pain, no way. Questioning witness Billy Cecil after a preface referring to him as a newbie, indicating a bias against his credibility of the witness. I don't remember all of this testimony. I don't know if he called himself a newbie or said that he was relatively new or whatever. Not great, but again, this one's kind of on the teetering. But again, what's crazy about this is they can go back into the jury deliberation room. I'm speaking so fast, I'm fumbling over my words more than usual. In the jury deliberation room, and they can say, oh, that one was a newbie. I don't find him credible. He didn't have enough experience. That's all fine. but putting it in questions beforehand is what creates an issue. Questioning after a preface with, is it possible Maya's waning abilities could be contributed to J Hatch, causing the limiting of family interactions, the stress and trauma Maya has testified to, documented statements by Maya about her mother's status told by hospital staff, Ms. Beatty. The juror statement not only flies in the face of the court's instruction to the jury about the role of DCF, but also accepts as true plaintiff's evidence long before having heard all of the evidence, as well as an opinion regarding the evidence, all of which violates the court's instruction to the jury. Again, I completely disagree with the characterization by defense here. The question is it possible this could be contributed to J Hatch? Meaning they haven't made their decision yet. Number one. Number two, it says the stress and trauma Maya testified to, not that it's true, just that she testified to it, which she did. And then documented statements by Maya. So this is all the evidence that they're asking. If you look at evidence like this, could it be connected to J Hatch? Totally fair question, in my opinion, and showing that they have an open mind and they're looking at the evidence and considering Maya's testimony just that at this point and not making up their mind. N, questioning witness Sally Smith by referencing plaintiff's testimony regarding the length of time that it purportedly took hospital staff to respond to telephone calls, thus indicating an acceptance of such testimony without having heard all the evidence and also expressing an opinion regarding the same. You could probably do this with like half the questions. The way a juror asks the questions means that they have to like take some fact into account to ask a question, especially if they want to provide context to the question. Because remember, some of this testimony could go hours and the jury's writing all these questions. So if she would have just, I don't know if it's a he or she, if this juror would have just asked the question above, could this be contributed to J Hatch? It's like, what's this? But you provide the context of the stress Maya testified to and documented statements made by this. So they put context because when they're writing it and the testimony ends 3 hours later and they hand it to the judge, the witness can actually answer the question. I think I read this one. Yes. Oh, during the same sequence of questions to witness Sally Smith, implying that the hospital itself was guilty of child abuse, the questions indicate an obvious bias in favor of plaintiff and against defendant and again suggest a violation of the court's instruction as outlined above. So I don't know what the specific question was, so it's hard for me to answer this. If in fact, of course, she said the hospital was guilty of child abuse and she already made up her mind about the end result before the defense put on any evidence, then that could obviously be problematic and reason for a potential disqualification. All right, now let's get to the standard. A party seeking to remove a juror for improper behavior in the course of a trial must show that the juror's actions amount to misconduct. A trial court must excuse a juror where there is a reasonable doubt whether the juror is impartial. Reasonable doubt to a juror's impartiality should be resolved in favor of excusing a juror. We don't want to take any chances. We don't want to have partial jurors making the decision. Bias need not be demonstrated with unmistakable clarity. Correct, but it also does need to be demonstrated. While a trial court is afforded a great discretion in ruling on challenges of jurors for cause, close cases involving challenges to the impartiality of potential jurors should be resolved in favor of excusing the juror rather than leaving doubt as to impartiality. While the decision to accept or dismiss a putative juror is considered an exercise in discretion, we view the seating of a juror as to whom there is reasonable doubt concerning impartiality an abuse of discretion and thus manifest error. So what that means is the judge does have discretion, but if he puts a juror on or he keeps a juror on that's partial, that is an abuse of discretion and a potential appealable issue that could overturn the case. As set forth, the standard for juror misconduct is satisfied in light of juror number one's apparent prejudice and bias revealed through the course of the trial and his questions and demeanor. So it's a man. And even if there were any doubt regarding juror one's bias in favor of the plaintiff, and there is not, that doubt must be resolved in favor of disqualification under Florida law. That would make it seem like anytime you ever cast doubt that they would be excused, and that's not how it is. It's not as cut and dry as that. As a practical matter, moreover, obvious bias on the part of a juror risks a hung jury if other jurors believe the juror in question has violated his oath. I wonder if they've been talking with each other, if he's already maybe affected some of the other ones. Finally, no party will be prejudiced by removing juror number one, given that an ample number of alternates have been chosen and the alternates in question appear to have been every bit as attentive as the primary juror. Such a procedure has been approved by multiple Florida courts. So this is an interesting thing I mentioned before. The fact that they have enough alternates and they could slide one in, if this is even close, I could understand why the judge would disqualify this one juror. Also, why I think it was a better move for the defense to just pick one and not try to do two, because it's not as huge of a deal to strike this juror and bring in an alternate. And it does show me that they're doing what most Florida courts do, where they picked a jury and then alternates, and the alternates are the alternates unless a member of the jury falls off, can't show up, or gets disqualified. In Alberger, for example, a personal injury jury was permitted to ask questions, as the jury here has. At the close of evidence, appellee objected to one of the jurors on the grounds that, from the nature and manner of the juror's questions and comments, it was apparent that the juror had shown bias and lack of objectivity, as in this case. The trial court submitted an alternate juror for the juror in question over appellant's objection. So the other side objected. Judge said, too bad, disqualified, put in an alternate, and did so without questioning the juror as to whether his comments amounted to prematurely expressed prejudicial opinion. I'd like to know what those questions were. I wish they would have cited some. If they were similar to theirs, I assume they would have cited them. If they're not similar to theirs, I assume the plaintiff will cite them in opposition. The third district held that there was no error in the trial court's doing so or in the manner in which they did, deferring to the trial court's discretion and finding that the juror was no longer objective and unbiased under Florida Standard Jury Instruction 1.1. In doing so, the third district noted that any purported error was harmless and that the alternate juror had been chosen, qualified, and present through the entire process. Right. You would assume the alternate juror is fair and impartial since they went through the same jury selection process. Although Florida case law is not uniform on whether questioning a juror before disqualification is necessary, Alberger supports the proposition that the act of questioning a juror under circumstances at issue could reinforce his or her prejudice or bias without cause. In addition, given the extent of juror number one's apparent bias, prejudice, and failure to follow instructions, any questioning by the court would serve no useful purpose, given that the juror is well beyond any rehabilitation and would risk alienating not only the juror in question, but also other jurors. So let me pick apart this part here. I think, without an absolute doubt, you should question this juror before disqualifying them. They've sat on this case for weeks. They're invested. Question them to see if they can be rehabilitated, see if they really are biased or not, see if they have an open mind, see if they've made up their mind. There's argument as to whether or not you have to do that as a judge, but I definitely think you should do it, and that is the wise way to handle it. Now, and it also creates a record, right, for appeal, because if the plaintiff's going to say they're not biased, we got to ask them and see what they say. That's what I would argue. Number two, the reason the defense clearly does not want the judge to question this juror is they don't want the juror to be rehabilitated. In jury selection, many times, one lawyer who feels like a juror may be good for them, but giving answers that could be arguably striking them for cause, will ask them more questions to rehabilitate them, like, regardless of everything you just said, could you be fair and impartial in this case? And the juror will say, oh, yes. And then sometimes judges will buy that and say, well, Mr. Tragos, even though they said they, hate all car accident claims and think they're all frivolous, they said they could be fair and impartial. It's like, judge, by their answer, it proves they cannot be fair and impartial. That really wouldn't happen because there's case law to say they have to be struck for cause. But in situations that are even close, if you just get them to say the magic words that they can be fair and impartial, sometimes that's good enough to rehabilitate that juror, keep them on. And I think the defense is afraid that if they come forward and are questioned by the judges or lawyers here, and the judge says, have you made up your mind? Because you're not allowed to. And the judge goes, oh, no, I haven't made up my mind. Can you be fair and impartial and still listen to closing arguments before you make up your mind? Sure, I can, especially if the juror really wants to go back and deliberate and they've been here for weeks. And that, I think, is what the defense is afraid of. The juror being rehabilitated and staying on this jury, especially because the juror is probably leaning toward the plaintiff. And I don't think there's a problem to lean. You can't make up your mind already, but you've heard all the evidence at this point. Tell me what you think. Do you think they will be disqualified? I'm interested to see how this goes. It's going to happen first thing Monday morning. Thank you, everybody, for joining me. Don't forget to subscribe, please, if you haven't already, and hit that like button if you've enjoyed this video. I'm out of here. Till next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.